Morning, everyone. As she went through my bio, I realized what a long, strange trip it's been. I have had the privilege of working in the environmental permitting system and environmental planning business from pretty much all sides. I have been a permit issuer, I've been an applicant, I've been an applicant's attorney. I've worked on large cleanups, small cleanups, and I was interested when I got the call to talk about this in terms of environmental ethics. As lawyers, we often think about ethics only when we have to. We worry about it, we avoid it. Why? Because if you have an ethical problem, you have a grievance filed against you, those are the kinds of ethics that we sweat. I'm here today to pitch, not preach, that we need to do better, that we need to broaden that view, that our obligation as attorneys, as officers of the court, go beyond occasionally doing some pro bono work, that they actually have to be considered project by project, day by day, client by client. I'd like to walk you through. Some of this is going to possibly offend a few people, and I'll apologize for that now. If you have comments afterwards, I'll be around somewhere and you can come tell me how you think. I'm going to take a long view. I'm not going to focus on the port, not really going to focus on things affecting Jacksonville today. I've been doing this for 36 years, and frankly, I think we have a long way to go. Go back to 1970, when we began this with Earth Day and the adoption of the Clean Water Act, the Clean Air Act, and NEPA. We had high ideals. We set very aggressive goals. The EPA, the Army Corps, and the federal agencies began to write new, tougher regulations. States began to adopt and implement their own laws. The concept of short versus long-term impacts was really a new thing. We started to focus on that. The need to take a balanced, reasonable approach. We articulated it for the first time. The idea of cost-benefit analyses, believe it or not, it didn't exist before 1970 to most of us. We started to focus on balancing, using that tool. And then the requirement to mitigate or reduce environmental impacts was also introduced. You heard some of that earlier as to the harbor and the difficulty in mitigating the impacts, the difficulty in considering alternatives. 40 years later, the good news. Potomac River in Washington, D.C., if you had seen it when I was a kid living there years ago, has improved from an open cesspool, and that's what it was, to a river that no longer stinks for miles in all directions. It may not be fishable, swimmable, it may never be, but it is a good example of the Clean Water Act and the improvements that can be made with it. Los Angeles Basin has much improved air quality thanks to new technology, well, new technology of 40 years ago, the catalytic converter, and the Clean Air Act. Pretty much took the type of air pollution that you're seeing in the newspaper in China, that's what it was like. And it's improved dramatically. NEPA required federal agencies to actually include the environmental impacts in the review of projects. That seems like old hat today, but at the time it was a major improvement. Then there's the bad news. And this is sort of the subtle bad news. This is not the capital B bad news. This is just what's happened. In the post-Reagan years, many people say that government is the problem. And that mentality undermines legitimate agency authority every day. In my view, it's a new strike one against administrative decision making. Who controls the purse strings? Budget cuts and layoffs clearly reduce our ability to manage this process and implement it. In my view, strike two against the environment. Court review of agency actions always gives broad discretion to the agency. Those of you in school now probably getting familiar with the Administrative Procedure Act. The courts defer to the agency as to its factual findings, as to the data that went into its decision and as to its decision itself, unless it's arbitrary and capricious. Well, that's a very difficult standard to meet. I would argue that it may go too far. A judge, on the other hand, would say, I don't want to get into the facts of a decision by an agency. I've got to rely on them for that. We've never gotten that fine-tuning quite right. So, the hearing records have become key, and many applicants' experts tend to stack. You heard the Army Corps gentleman describing all the different backups, independent peer reviews, and external reviews of projects and project details so that their agency record is as strong as it can be. Part of the problem is applicants know that you need to build and own the record. If you build and own it, if it's yours, then you can defend it either way. And so, again, some of that deferral to the agency discretion and the ability of the applicant or permittees to push the record and own it work against us. Now, the ugly. The recent coal ash pollution incident or disaster in North Carolina shows how inadequate the delegation of permitting to the states can be under the Clean Water Act. I'm using this one because most of us have seen it on the news. Huge waste coal ash storage pond located immediately adjacent to the Elk River. Why was it ever there? About 82,000 tons of waste ash spilled into the river, impacting drinking water and other uses for weeks, now months. And there are 32 other ponds in North Carolina owned by Duke Energy. We'll see how they go. The state agency had become a captive of the regulated industry and had looked the other way for years. When the state was going to Duke Energy to address the spill, the North Carolina governor intervened and tried to settle the case for $100,000. Now the North Carolina U.S. Attorney is looking into it. The $100,000 settlement has been voided. So this is the type of worst case, ugly scenario. Let me bring it closer to home. Everybody knows that picture. I don't need to tell you what it is. It was one of the most, well, in terms of affecting Florida, the oil spill caused the death of a dozen folks, and there are now millions of gallons of oil and oil sludge in the bottom of the Gulf. It was an unprecedented incident in our coastal waters. We still don't know what the long-term impacts are going to be. Again, a captive agency, lack of inspections and enforcement. BP's response sounded something like deny, deny, stall, underestimate the impact, underestimate the volume of spill, fudge the numbers, finger point at the other parties, spread a toxic disbursement agent without EPA approval that would make the oil go away. It didn't go away, folks. It's still out there, down on the bottom. There's a research doctor, MD, up at Auburn, who's now looking at the resulting tar balls that are coming up on the Gulf Coast. And she's found evidence of a flesh-eating bacteria in them. You'll be hearing probably more about it. She's just in the initial stage and just got funding for more study on it. The bottom line is we think we know what we're doing, and when we screw it up, it turns out we may not. And one of the things that bothers me is the whole thing seems to have gone away. It's off the radar. It's not in the news. It's as if, not that it never happened, it's just, I'm amazed at how quickly we can turn the page and move on. Which brings me towards a more ethical process for environmental decision making. We still have a number of issues to address to try to do this better. We still need to rethink our approach to a balanced, reasonable decision. One can argue that most decisions are fair and ethical, that it is the exceptions that are the problem, like these two that I showed you. Those are exceptions, you'd say. And that we should not overreact in ways that would hurt other compliant applicants or operations. My personal view now is that we have underreacted, not overreacted, for decades. I believe that we've also undervalued the real worth of our natural resources. Frankly, in my view, there are just too many mistakes, spills, illegal discharges, and algae blooms to bring it home, to ignore these issues. Too many budget cuts and political trade-offs, and then the rough economy kept us all focused always on jobs, jobs, jobs. So, again, I don't think that we have the right approach for a sustainable environmental control going forward. The current permitting machine is not enough. With apologies to hardworking staff at all levels of government, and I've served in most of them, I no longer think the system that we built can adequately protect the environment nor the specific resources that are to be held in trust. It seems to be a winner-take-all mentality that controls the day on permits, and therefore the deck is stacked against the public interest and the natural resources that are held in trust for our children and grandchildren. And I used to think, well, you know, he's talking about grandchildren. Years ago when I was in law school, I wasn't married yet. Well, my kids have grown up, one's gotten married, and actually, who knows, there may be a grandchild around the corner. So, for the first time in my life, I'm actually thinking, wow, I've got a grandkid, and they're going to inherit what? What am I leaving them? Although we don't talk about it much, as officers of the court, we have ethical obligations to more than our clients' best interests. We also have an ethical duty to the public interest that goes beyond doing pro bono work. We have an obligation to explain to our clients that there are likely limits to the permitting system, to explain what a balanced and reasonable approach is, and to even explain the ethical concerns about project impacts upon the public trust. Of course, agencies and the staff do that in discussions and negotiations with applicants and permittees, but I believe the lawyers need to actually step up and perhaps, frankly, for the first time, take the public trust interest involved and put it on the table to discuss with our clients. Even when they slough it off and go, Don, I hired you. Are you my lawyer? The answer is, you bet I am. But I need you to understand the issues, the pushback, the agency focus, what the public's going to say. I could get you a home run, and yet the PR impacts could be a disaster for your company. And again, I'm amazed with BP. Where's the PR impact? Did we address those issues? Are they still getting permits to drill a mile down? I don't know. But I need to pitch to you that as lawyers, we need to broaden our view of our ethics. Because at the rate we're going, you've seen these photos, you're reading about it every day, we're not getting it right. Our clients need to realize that proposals will do better if they are designed within the regulatory framework. A compliant, more balanced project often saves time, costs, and avoids negative PR. Now, not to say that I'm an optimist, but putting that aside, in case we are not able to do what I'm urging you to do, I think we need a plan B. The environmental costs and impacts that I've showed you and that you're going to hear about today have been viewed as externalities. We need to incorporate those external costs into the whole process. We have not done that adequately. We need to start doing that now. Sometimes government leaders have ignored those external costs, those damages, and said that the jobs are too important. That's a short-term view, and one that too often everybody nods their head, and yet when you drill down in the numbers, they don't hold up. So Again, I think Plan B would say that we will need to include the external costs into the process. We're going to need to monetize those impacts and objectify them as best we can. Recently, some of our Florida delegation have stated their opposition to subsidies, but by granting this kind of freebie on these external costs and damages, we effectively have given them a subsidy, and we need to stop that. So the bottom line in environmental permitting should be include all costs and halt the presumption that permit applicants and operations are entitled to a subsidy. In closing, I'd say to you that you all in particular are in a unique time in Florida. We're at what I call a crux point. We're in the 7th inning stretch. It's about to get very serious, folks. We have a limited amount of fresh water available. The agencies in charge of that have just effectively announced we have gone from an infinite supply to a finite supply. We've got to discuss meaningful changes in the way we do things. We need to change our narrow win-lose view, and we need to rethink our inclusion of external costs for environmental permits. If we can't do this, I'm afraid we're headed for a time that Mark Twain foresaw many years ago. Whiskey is for drinking, water is for fighting. Thank you.
Thank you, Ron. Our next speaker is Ms. Watson-May.
Okay, so far so good. Hi everybody. I'm interested in understanding a little bit more about our audience. I know we've heard from a few agency folks. If I could just ask, how many law students do we have in here? Show of hands. Okay, that's great. And how many folks from industry, the regulated community? Just a few, okay? And regulators or agency folks, staff? Okay, great. I appreciate that. That helps me understand a little bit about our audience, and it's interesting to hear the different perspectives. I really like what the law school has done with having people from both sides, or all three sides, depending on how you look at it, because I think that makes the discussion more interesting. When I was asked to talk today about environmental compliance, and Professor Hall said, let's try to make sure there's an ethics component, because we all like to get ethics CLEs. But I also think it's a good discussion, and it helps us talk about how ethics play a role in corporate compliance. And I think you'll hear from Professor Sneirson over here also a different perspective, and even what you heard from Mr. Blanchard. A lot of folks think that companies don't want to comply unless you can prove that it's cheaper to do that, and that they're always asking that question. And I'm here to tell you, at least from my experience, I've been very fortunate to work with companies who think compliance is the right thing to do because it's the right thing to do, and they think it's more cost effective. So let's go through a little bit of maybe some examples, as well as the rules that bind us. So there are legal and ethical obligations, maybe moral obligations. We'll talk a little bit more about that. But particularly for lawyers, when we're presented with non-compliance, contamination, a release, and the duty to disclose information. I'm also going to touch on professional engineers and professional geologists, because that's who I work with a lot, and we have similar obligations to our clients and to the public. So here are some basics why we should make the disclosures. Sometimes the law says we must. Sometimes it helps us if we come forward and we say, we've made a mistake, then it's obvious that there shouldn't be criminal sanctions, because agencies are always trying to decide, is this a civil case, is this criminal? And they're looking for conduct which would rise to the level of criminal liability, such as trying to hide the truth, trying to cover it up, bad. There are other reasons, policy goals, your company says environmental compliance is important to us, so that's why we're going to do it. It can also help minimize bad publicity and minimize risk of litigation or penalties. The more the agency sees that the company is trying to comply with the rule, get it right, implement corrective action, make sure it doesn't happen again, they're going to be much more willing to work with you on the penalty. Repeat violations, hallmark of that's when the penalty really starts to go up, because you're showing them that you're not putting the priority on compliance. So we're going to talk about ethics rules, legal obligations, which include maybe what the statute says, but also common law, and your contract. If your contract requires disclosure, then that's another obligation that goes beyond just your ethical obligations. Moral obligations, and then I'm going to add agency guidance documents where sometimes, in particular, EPA has a self-audit policy that says if you discover it through your own systematic audit and it meets certain criteria and you disclose it within 21 days, then you can be eligible for significant mitigation of your gravity-based penalty. And that can be a really important help to companies to come forward and come clean and figure out how to get it right so it doesn't happen again. So ethics rules, lawyers' rules of professional conduct, Rule 4-1.6, talks about when the lawyer shall not reveal information except in certain circumstances, unless of course the client consents. And then there are times when a lawyer shall reveal confidential information to the extent reasonably believed necessary to prevent a client from committing a crime or to prevent a death or substantial bodily harm. Now keep in mind that with the disclosure, the crime doesn't necessarily need to relate to substantial bodily harm. So those are two independent issues, and I point that out because you're going to see in a minute, committing a crime under environmental laws sometimes can have a pretty low threshold. It can even be for negligence, which I'll say at this point, in-house environmental lawyers, or in-house lawyers generally, I think have a tougher row to hoe when it comes to ethics. For outside lawyers, it's easier for us because clients come to us and say, this is what we're dealing with, this is what we need guidance, and you're not always given all of the information. So we don't typically know about things unless the client tells us. In-house lawyers, on the other hand, often have a blend of business responsibilities as well as legal responsibilities, and they typically know a little bit more about the business. So I would suggest to you that those are the folks who probably have the biggest challenge in helping their client, like Mr. Blanchard was saying, explain to the clients what their obligations are, what they need to be focused on, and why they need to focus on responsibility to the public as well as their specific obligations. For lawyers, we also have times when we may reveal information, even if the client doesn't consent. Typically, they're going to consent if it's to establish a claim or a defense for the company. If it's a dispute between the company and the lawyer, that becomes a little bit more complicated. To respond to allegations, again, the client probably is going to consent to that. And then the rules of conduct, which we've already talked about. So as I said, with environmental crimes, here are a few examples. Actually, I'm going to jump ahead. I came to this slide too quickly. Other professionals. Professional geologists shall advise the appropriate public officials when the decision of an employer, client, or colleague violates any law or regulation if such violation appears to materially affect the public health, safety, or welfare. So there's a threshold that only if the violation appears to materially affect public health. And I'm going to go into some examples in just a minute where we can think about how that occurs in real life. Similarly, the professional geologist has a confidentiality obligation and can't disclose confidential information obtained from a client except with the consent of the client or when it's required by law. Professional engineers shall notify their employer if or such other authority as may be appropriate. I presume that would be some agency if there's been some problem. If the engineer's judgment is overruled under circumstances that endanger life or property. The Florida licensed engineer also has the obligation to keep confidential information confidential, except they can disclose it as authorized by law. The engineer can be sanctioned if he fails to inform his employer and the responsible public authority of possible circumstances when an unqualified person has overruled the engineer's judgment with the result that public health and safety is threatened. So again, geologists, engineers, and lawyers all have an obligation to keep information confidential. There are times when we're supposed to disclose that. So the environmental crimes, I just wanted to point out, if a lawyer is supposed to disclose when a client is going to commit a crime, then just take a look at some of the environmental crimes. The first one, under the Resource Conservation and Recovery Act, imposes criminal liability on a person who knowingly treats, stores, disposes, or transports hazardous waste or used oil in violation of RCRA, even if it doesn't place someone in imminent danger or imminent danger of serious bodily injury. Jump down to bullet number 3. The Clean Water Act imposes criminal penalties for failure to report a discharge of petroleum or other hazardous substances into navigable waters, including negligent violations of a permit condition. Anybody in this room surprised that negligence can rise to criminal liability? Nobody's surprised, okay. Florida statutes have similar criminal sanctions for knowingly causing pollution, failing to comply with a rule, or knowingly falsify a statement or report. So if the lawyer or other professional has an ethical obligation to disclose information, what if it's not clear? How do you know? You know, a lawyer isn't a doctor or a toxicologist or an engineer, so how do you know when you've reached that threshold? Is it chronic long-term exposure? Is that enough? What if it's chances of developing cancer when the exposure risk is 1 in a million? What if the chances are unquantifiable? Obviously, some things are easier. You know, what is contamination? It's defined in Florida statutes, not necessarily in other states. It can be clear when you have found, is this contamination that requires disclosure? You can look at the statute. Sometimes it's very clear-cut. But there may be other definitions, and sometimes it has different expectations. So for example, if you're talking about public policy considerations, well, maybe it doesn't meet the definition of contamination under the statute, but maybe you think, well, the community would like to know, so maybe that's a reason that you disclose it. In the contractual setting, I think we'll get to that next, the seller of residential property is obligated to disclose in Florida latent defects. But in a commercial transaction, there is no such obligation. Now, as a buyer, you're going to say to your seller, you know, you need to give me a representation and a warranty about the condition of the property. But a lot of buyers may be unsophisticated. Commercial property buyers often are, and they will say, well, of course I thought they were going to tell me there was asbestos in the building. Aren't they supposed to? Isn't asbestos illegal now? You know, so there's a lot of misconception out there about what you're going to be told in a transaction or what you're entitled to know. So you've got to look at the statutory requirements. You've also got to look at the circumstances surrounding the situation, whether it's a contract or a community situation. The examples I gave here are lead-based paint. Well, that's a little bit easier because there's a federal law requirement for residential. What about mold? Does everybody think that mold is, you know, contamination, or if you're going to buy a building and it has mold in it, you think you should be told about it? Do you think it's a health risk? There is no standard for mold, and so you probably aren't going to be told about it, but it can cause health problems, so some people would expect you to tell them about Asbestos is a little bit more complicated. If you're a commercial property owner, you need to understand asbestos regulations. It's regulated under the Clean Air Act, and it's delegated to the state, and in Jacksonville to the local agency. But a lot of people have real misconceptions about asbestos. Environmental release or contamination, we talked a little bit about what that means. Again, there are statutory requirements. There's off-site contamination, petroleum contamination, lead-based paint. There are some specifics. Sometimes you have to ask for it, though, before you're going to get that information. Radon is another example. It has to be disclosed in every real estate document, whether it's a lease or a purchase, even if it's commercial property in Florida. So who is entitled to receive the notice? The regulators sometimes. If you're about to renovate or demolish a building that has asbestos in it, you have to give a 10-day notice. Sometimes you have to tell the tenants also if it's a commercial building and you have existing tenants. The property owner, if my neighbor has a dry cleaning operation and the contamination is migrated off-site, the adjacent property owners are going to get notice of that contamination. In Florida, the notice is given by the Florida DEP. Employees, in the example of asbestos, construction workers are required to receive notification that of hazards in their workplace. There's a specific provision for asbestos. So disclosures can be given in a lot of ways, obviously verbally, in writing, sometimes with contamination remediation at sites or asbestos abatement. There'll be actual warning signs posted. Sometimes it's at a public meeting when you think that that's going to be the best way. When the notice provisions first came out, where the states decided when there was a contaminated site, they wanted to notify property owners, they would send out this letter. And I can tell you from experience, when people get a letter out of the blue that says there is contamination on your property, or there's contamination next to you and it's migrating under your property, people get very anxious and very worried. So I would advise my clients, if you know that your industrial facility has caused contamination and your neighbors are about to get that notice from the agency, don't let that be the first time they've heard about it, because their anxiety level goes up. It's much more effective if you reach out to everybody and explain to them what's going on, tell them what you're doing about it, how quickly it's going to be addressed, are there any health concerns, should they be worried about their kids. Moral obligations kind of goes along with that. Public policy considerations, sometimes it's better if you hear it first. One of the examples I'll give you, I see I'm a little short on time, is there was a school built on a former industrial site that my client used to own. It was taken by eminent domain, and the entity that took it knew it was contaminated, didn't clean it up, built an elementary school on it, and then, 15 years later, somebody figures this out and contacts my client. They're very upset, want to know what happened, how could you possibly let a school be built? And so much time had passed, people change at a company, they didn't even know what had happened. But I can assure you that they ended up being, in the media, in the hot seat. We did public meetings to try to get out ahead of it and explain to people, and it ended up, being probably a $5 or $10 million remediation when, because the school district didn't have any money to deal with it. Cost of noncompliance, it's something that came up in our discussion we were getting ready for today, and I mentioned earlier, I do not have the experience of clients asking about, well, I don't know, should we really apply for that permit? It has happened to me twice in 17 years, and in both times they were very unsophisticated clients who did not understand the permitting obligations, and I think did not intend to act on it. It wasn't like, okay, now I'm not going to apply because you told me the penalty might only be X. In every case, my clients have said, well, obviously we need to get the permit. I do have a situation where somebody, and this is here, where during the condo boom, oh, let's build this property. Oh yes, we've got to get this construction underway. The investors are really excited to build the property. And they got out ahead of themselves. They were waiting for the permit approval to clear the land, and they were just sure it was coming, and they jumped the gun, and they cleared land, and it turns out their permit was denied because they wanted to clear land that was part of a conservation easement. And then I was like, oh, you know. So it does happen, but I have to tell you, it's really rare, and maybe we'll have a little chance to have some back and forth about some of the other specifics. And I think I'm out of time, and that is all I'll cover for now. Thank you.
Thank you, Ms. Watson. Our next speaker is Professor Judd Sneirson.
Thank you, and thanks to Eric for organizing this conference, and the Florida Coastal School of Law and Jacksonville University for inviting me here to present. Particularly, it's great to be here from Savannah, where we have the 4th largest port in the country, and would like to keep it that way. So I'm approaching this issue of corporate compliance from a different perspective from the other panelists, and also from maybe a different perspective from most of the people in the room, because my specialty is corporate law and not environmental law. And I'm looking at the corporate law and piece of it, and what corporate law, if anything, has to say about corporate compliance. So a little bit about the background of corporate law here on this topic. So, you know, for the law students in the room especially, maybe you remember Dodge versus Ford or Revlon, or one of those cases that you did in corporate law in your corporate law survey course. Notwithstanding those couple of cases and the colorful language from that old Michigan decision involving Henry Ford, there is no legal obligation for companies, for boards, for officers to maximize the shareholder returns. Yeah, there is this norm. There is a prevalent norm in American business to try to do that, which means that even though there's no legal obligation to do so, the people running companies believe that that's their job, and that's what they head into the office thinking as they make their decisions. So what are the requirements of these people running companies? So they, in addition to whatever statutory requirements come from other areas of law, as far as corporate law is concerned, they owe fiduciary obligations to the company to act faithfully, loyally, in other words, in good faith, reasonably carefully, although that one is kind of watered down, and to obey the law, to obey applicable laws, criminal, civil, administrative, and so on. So that's pretty clear. Not quite as much in the corporate law world on that last bit about obeying the law, but there are a couple of bigger cases, including this one that appears in most of the case books, Miller versus AT&T, which involved the 1968 Democratic National Convention and AT&T's illegal campaign contribution to that convention. And there, the Third Circuit interpreting New York law said that, yeah, there is this obligation to obey the law, and what's more is that this obligation exists even if you can disregard the law, and you could make more money by disregarding the law, paying whatever the fine is, and you know, that's not a good enough reason. You have to comply with the law, even if it would be more profitable to not comply. And so there's similar case law in Delaware, which is the most important jurisdiction for corporate law in the United States. And here's just a little money quote from one of those cases. Under Delaware law, a fiduciary may not choose to manage an entity in an illegal fashion, even if the fiduciary believes that the illegal activity will result in profits for the entity. So pretty clear, statement, and there are other statements in other Delaware cases. So the law is fairly clear on this issue. So the corporate law scholarship, though, which is heavily influenced by the law and economics movement, has some additional things to say about the issue. First is, for efficiency's sake, the idea is that cost-benefit analyses should be done in any compliance situation to figure out if compliance is the best route, the most profitable route, to serve the shareholder value, the shareholder interests. And so in the name of economic efficiency, when non-compliance is the more profitable route, the law and economics corporate law scholarship would encourage some amount of non-compliance with applicable statutes. So these papers, the scholarship views penalties, the penalties for environmental violations or labor law violations or any other kind of applicable violation of applicable law, views these penalties as just costs of non-compliance, costs, prices basically. You either comply or you pay the price and go on with your business. And so the shorthand for that is viewing statutes as prices or law as price. Even the hardcore law and economics people, though, do concede that certain laws shouldn't be treated as prices. And so those kinds of laws are more non-negotiable laws treated as limits. So what are those reserved for? Usually the dividing line for these scholars is somewhere in the line between malum in se and malum prohibitum, for the people who remember those terms from law school. The difference is malum in se is something that's inherently bad, so like something involving violence or health and safety would probably be in there. Something that is maybe as a natural law matter a bad thing to do. Whereas malum prohibitum is something that is not inherently bad. There's no moral imperative associated with the law or compliance, but rather it's just something that's prohibited. So think of maybe double parking or speed limits, things like that. And so by distinguishing between malum prohibitum kind of laws, which would be viewed as penalties or prices for non-compliance, a lot of statutes, a lot of maybe environmental and labor statutes even, would be included in those in that category of statutes which are viewed as just mere cost of doing business. The one law and economics piece that cuts the other way, though, is this concept of externalities, which Don mentioned earlier. These are costs of doing business that aren't kind of felt, absorbed by the firm in making their calculations of how much to charge, how much to produce, and so on. And so externalities to economists are bad things, and so they should be incorporated into calculations. And so to the extent that there is pollution going on, even allowable pollution going on, that would be an inefficiency that law and economics would not like to see. So I guess here's an example to try to make it real. In this hypothetical, there is a company that can use a lower grade fuel, and if it used this lower grade fuel, it would likely violate the Clean Air Act 4 times a month, but doing so would save $80,000 a month. And so if we just kind of pick a number which is maybe a little low, but good for the math, $25,000 per violation, that would suggest that 4 times a month times $25,000 is more than the savings, and so the company should comply. But that's just the beginning, because we have to discount the $100,000 in fines according to the chances that a company would be actually caught. And so if it gets caught 3 out of 4 times, or if it gets caught maybe 90% of the time, then the $100,000 is down to 90, so still more. We further discounted according to the chances of having to pay the full fine. The EPA, for example, probably the state analogs also settle a lot of cases. Sometimes cases are brought to a hearing and the company doesn't have to pay. And so if there's some chance, maybe again a 10% chance that they won't have to pay, or that they can settle for less, then that is an additional discount keep in mind, and so the balance is sort of shifting in favor of non-compliance. And then the last discount that we would apply is the time value of money. The $80,000 in savings is an immediate savings and an immediate benefit to the firm, whereas having to pay, I guess at this point we're close to $80,000, a little bit more than $80,000. Having to pay that a year from now, or a little bit more than a year from now, I don't know how long these things last, but probably that'll be fast. That will make the difference and tip the scales in favor of non-compliance. And then to make matters worse, managers, when making these sorts of estimates, tend to underestimate the costs, they tend to underestimate the chances of getting caught, and they tend to overestimate the benefits that they'll enjoy by non-complying. And then just as a side note, before we get to the next slide, Stacy mentioned that her clients, her sophisticated clients, want to comply, and so I guess the question is this a real problem that we're facing? And I would say, while many of her clients and many businesses do want to comply and do the right thing for cost-benefit analysis reasons or for other reasons, there are certainly examples of companies that won't, like the ones that Don mentioned with his pictures. And so what are a couple of corporate law solutions to the problem, my area of expertise? One is to move the line between laws that are treated as prices to laws that are non-negotiable. And so if we move, say, environmental and labor laws to the non-negotiable side, because after all they do involve health and safety, and there is a moral component to it, then we're bringing more important statutes into the outside of this cost-benefit analysis area. Another one is ultravirus, which is this largely forgotten doctrine from corporate law, but one of the points of ultravirus is that there are certain things that a company just doesn't have the power to do, and so I would posit, and other people have posited, so I'm not really making this up myself, is that companies don't have the power to break the law. And then a third one is, as a corporate law or a securities law matter, to require disclosures which currently aren't required as under those two areas of law. There are other solutions which I'll hopefully get through quickly in time to close and leave time for questions. One is improve enforcement. This would cut down on one of those discounts if enforcement was more likely to catch people who are violating labor or environmental laws. Another couple of ideas involve somehow increasing the penalties for noncompliance. Maybe imposing individual liability on the actors who make these decisions, criminal liability. Otherwise account for all of those discounts like the time value of money, the chances of having to pay, the chances of getting caught, and so if we up the penalties to account for these discounts, then at the end of the day, the penalties reflect what they should cost. Another point that John mentioned is to cost in the externalities that companies face, which would be something that economists would enjoy because it's efficient. And so if we cost in the externalities to increase the penalties, then we are further encouraging compliance. And then the last two ideas involve increasing the benefits for compliance. If you've ever bought something with a fair trade label on it or a B Corporation with a logo, then you probably understand the kind of the draw, at least to the consumer, for buying something from a company or from a manufacturer or at a store that is kind of a good corporate citizen. And the flip side of that is to do a better job of shaming the firms that don't comply. I think the EPA website and probably the state websites too do contain lists that are a little bit hard to search and figure out of companies that are polluting and violating labor laws. And so if we make that easier and kind of empower the people, either muckrakers or media or others, to shame the firms that don't comply, we can kind of increase the cost of non-compliance through bad PR. So those are my points, and I look forward to pursuing any of your questions in the Q&A. Thank you.
Thank you all for speaking on this important subject for all of us, whether we be lawyers or not. I really would like to latch on to one of the last statements that Mr. Sneirson talked about, and that is the matter of shame or dealing with PR. And I think it's actually even a deeper opportunity for us as a community, not just depending on lawyers, but on all of us with respect to culture, a culture of winking on certain things within a corporate community or within a political community. It seems from the outside sometimes that there is a complacent attitude among maybe some of the regulators, some of the politicians setting policy, some of the corporate or financial people that are involved in the large organization activities. And I would suggest that lawyers and their clients should maybe consider that there's a more powerful force out there, and that is public culture. We didn't eliminate dueling in the elite crowd until it became a shameful act and was ridiculed in print, and people would be shunned from their local community circles if they got involved with dueling. And when we have financial dealings that lead to nobody getting convicted of any crimes that were debilitating to our whole economy, or when we have a culture of repeated violations of spills of coal ash or nutrient pollution from unmanaged activities, who's at fault? Who can advise? Who can make more noise about it than the people of the community and the circles of influence that relate to that? And I think that's something we should all think about.
I have just a couple of thoughts in response to your question. One of the great things I think about the shaming approach is that it works within the current system of the cost-benefit analysis to the extent that companies are doing that, because what you're doing is motivating people to increase the costs for doing some bad things, like violating statutes, labor, or environmental, or other ones. And I think the other good thing about the shaming approach is that it works to change the social norms in business that do a lot of the work. And changing the social norms towards more of a compliant norm would be only a good thing.
Well, and if I could add to that, I do think that increased enforcement is a good thing when it particularly focuses on the bad actors. Because, when he talks about the discount factor, oh, well, we're going to discount the penalty, we might not get caught, we'll negotiate it down. That might work the first time, but that's not going to work a second time, because the agency is going to know that, when you said that it was an accident and that you didn't mean to do it, they're going to know that you were lying. And I would suggest that, we've talked about ethics, but maybe even more important than ethics is credibility. And as lawyers or professional engineers, professional geologists, I am not going to go to a regulator and say something unless I believe it's true and that I have a good faith basis for that. So if somebody wants me to help them make that argument, that it's, well, we'll just negotiate it down and okay, you can keep doing it because it's cheaper, I'm not going to continue to represent that client. And so that's one thing that lawyers can do to help that, because I think our credibility, and I think that's true of the companies too, and the folks I work with in the EHS world take that very seriously.
And my view is that we've got I like the notion of good faith. I'd like to start there. You all recall that there's implied in all contracts negotiation as to good faith and fair dealing. I wish there were a similar type of requirement in environmental permitting and disclosure. Unfortunately, what happens is, as Stacy described, many of these violations occur, they're small, they're incremental, they're repeated, and they develop many operators develop a sort of, there it goes again today. Well, we'll fix that, call Bob. And over time, what may have been an innocent enough first occurrence, second occurrence, third occurrence, gets to be, in my view, a culpable violation, fourth offense. And they didn't mean to be out of compliance, they just are. And then at what point is it really damaging? So shaming, I think, works, but I think it's all tied in to what the professor mentioned about shareholder value. 25 years ago, we didn't talk much about shareholder value. Then we invented, or didn't invent, but started to use stock options to align corporate officers' interests with the shareholders. So if the company is going to profit and the shareholder profits, then you, officer of Corporation X, get to profit as well. Well, unfortunately what happened was that same good faith concept got twisted, and corporate officers began to push the envelope and realize that if they could hedge a little, cut a little, nod and wink a little, deal with the regulators where they could, maybe use some of the professor's examples, that they could increase their shareholder value, but that in turn increased their value. And so the combination of good faith and bad faith, of what I'll call slow creep, sort of accidental violation, and then the notion of shareholder value as the god of corporate America has got to stop. And I think those kind of all go together. I would give a shameless plug to CSX and some of the local companies that do a great job on compliance, but generally we're talking about those that don't. And I agree with Stacy, not all companies take a slash and burn approach. Many are very focused on good compliance activity and try very hard. But shaming is there. I think I like the professor's concept of ultra vires, beyond authority. It can cut right to the issue of, wait a minute, corporate officer, you did this, you exceeded your limits of duty, right? You have acted ultra vires, beyond authority, and therefore that may give rise to personal liability. It certainly will blow out any corporate and director officer insurance coverage. If you exceed your authority and act beyond the scope of duty, you're on your own in most corporations. So it's an interesting mix, and I think shaming is kind of, I don't want to say it's the last, but boy, we the public, unfortunately, other than many of the groups that are probably here, it's an uphill battle for us to mount that kind of PR campaign, raise $100,000 and start getting it out to the media. So it's a good idea, but I think we're going to have to kind of work on all of them.
It's also important to recognize that public companies do have an obligation, and I think you touched on securities disclosures. The public companies, and I recognize this doesn't address non-public, but public companies are required to disclose in their public filings what kinds of environmental liabilities they have, contingent remedial obligations. So if they've had a lot of big spills around the country, they've got to make sure to put money in reserve to address that cleanup, and that's monitored by the SEC. They also have to disclose if they have an enforcement action, and I think the threshold for reporting that is where the penalty is likely to be $100,000 or higher. So there is an opportunity for shareholders to be informed about what a company is doing, how many of those they've disclosed. They're also supposed to disclose any trends that they see coming that could have a material effect on the company's, financial wherewithal, their bottom line.
And I guess it's back to me. So, since we're going back and forth, the one catch that you mentioned, Stacy, just now is that the securities laws view things through the lens of materiality, and so if something is below that threshold, then it usually doesn't have to be disclosed. And so, depending on the level of the violation and the size of the company, something might kind of sneak under that.
No, the number is set, $100,000. It's not a materiality threshold for that disclosure.
For
environmental?
Yes.
Okay.
For enforcement things, perhaps, but just for,
The trends, you're right.
Right.
Yes.
Can I make a couple of points, please? Firstly, I'd like Professor Sneirson to comment on shareholder lawsuits. Secondly, I worked for most of my professional life as a risk manager, and we considered that I considered at least, that one of our prime responsibilities was preserving the reputation of the company. And I think that goes beyond shaming, because the reputation of its damage can impact the earnings of the company and the long-term viability of the company. So I appreciate your comments on those two.
Yeah, I absolutely agree about the reputation of the company. But to just use BP as a recent example, they were, until the Gulf oil spill, the place where people would drive their Prius up to fill up. And now the Priuses, whatever, just drive right past. As far as the shareholder suits, the way that the suits would be brought would be on behalf of the company against the individual directors or officers who engage in these knowing violations of the law. So even if the company made money off of the violation, they would personally have to reimburse the company for the extent of the fine, and so the company would be made whole for doing the fine if the shareholder suit was successful. And to Don's point, to kind of agree with Don's point, this would be outside the exculpation provisions of Delaware and other states, and probably be outside the scope of corporate indemnification obligations, and also outside the scope of the policies, depending on what the policy says. But to do an illegal act would probably be outside the D&O policies.
I'm Professor Pagano for Coastal, Celeste. I want to just thank all the panelists for a great panel. And Professor Sneirson, this conversation has me thinking of the point you made earlier, because I'm a law professor and I get drawn to the Latin, right, of the malum prohibita versus the malum per se, and where we move the needle on what we think of as immoral activities versus what we think of as things that are just inherently wrong. I mean, that are just illegal as opposed to inherently wrong. So it's interesting to me how the kind of 3 points, the 3 solutions you make are sort of tied, right? Because once we have the publicity element that some of the questioners have asked about, the shaming element, if we're going to call it that, and just the PR element, and the awareness of the environmental issues, then that needle moves, and it's easier to perhaps pressure our politicians to move the economic factors, the things that remove the discounting, the things that make Stacy's job easier, So anyway, I don't know if anyone wants to comment on that, but it was just something I observed that I really appreciate.
Yeah, I agree. Moving the line helps in terms of what people will view as non-negotiable and what people will view as just a price of doing business. It also helps the norm. It also helps the PR. So I think it has a lot of implications. I agree.
The only thing I'd add, though, unfortunately, is that the calculus of cost of doing business is skewed unless there is hard enforcement activity. As a former financial sector regulator that worked in New England, we put 27 people in jail from that crisis in 3 states alone. Lawyers, bankers, investors, realtors. I use it as an example. This last go-round, I don't think anyone's gone to jail. If you don't enforce the rules, most corporations, in my experience, don't feel they have to abide by them very much. So I would say to you, it's shaming may work, but by God, what we've got to have is strong enforcement that gets people's attention and makes the calculus of violating the rules too high. It's no longer a cost of doing business. It goes right back to the gentleman in the back. As a chief risk officer, he gets to say to the board of directors, no, this is a step too far, if it ever gets to that level. And his job is to hope that he can resolve it well before the full board at a committee level. But you've got to have the strong enforcement, or anybody in any industry, financial, environmental development, land use, whatever, tends to take it less seriously. And from my experience, that's the beginning of a very bad slope.
John Flo with City Environmental Quality, which makes me a regulator, and I also happen to be an engineer. I feel compelled under the ethics code to disclose I'm an engineer, because when I'm addressing attorneys, I have to call to mind all the jokes that we tell about each other.
Have you got a new one? I'd like one.
I don't have anything. Well, you know, the whole thing about why scientists don't use lab rats and more use attorneys.
Exactly.
There's some things that even a lab rat won't do. My wife
It's an oldie but a goodie.
My wife is fond of saying about engineers, often wrong but never in doubt. I like Tom Larson's comment about image and the number of reinforcing comments that he made. While he's talking about building a big hold of mine, the ultimate shame used to be tar and feathering, I think. But is that still lawful in
No.
But your example of handcuffs is, and I've seen that work here in Jacksonville. It does get a guy's attention when he gets in the back of the cruiser, and his construction site is shut down while he goes downtown to read books. And perhaps that is needed more, and it landed well media coverage as well. My question really is, as a regulator to attorney, that's the fun part. And I guess it's for any of you who wants to comment on how in the world do we ever get to thinking of corporations as persons in environmental law, and the fact that the local statutes say the name in the definition of person. Thanks.
I'll be happy to take a stab at that. You want to?
So,
You're the
You go
corporate.
Well, I mean that. So it's an entity separate from the shareholders is usually how it comes up. But lately, of course, in constitutional law, not my area, I need to disclose. There's First Amendment possibilities, and now with the Hobby Lobby case, there's First Amendment religious possibilities that are before the court now. I think a lot of it is just a function of making companies so that they can sue and be sued and enter into contracts and stuff. So a lot of it is it sounds worse than it is, but the part I think about it that is as worse as bad as it sounds is the constitutional element, and I guess the amount of capture that companies as a result of that tend to have over government and agencies.
Right, and I think in its simplest form, it's the way that we have created corporations, because a corporation could be owned by 2 people or 100 people or many thousands, and if it isn't separate from its owners, then how do you treat it? And we have, as a society, created a corporate structure so that an individual who owns the company isn't personally liable for the company's obligations, because the company is acting, on behalf of all of its owners, not just one person. So it is a fiction, but it's a necessary fiction to make it operate. But let me tell you that, again, in my experience, the people working in companies are who are in charge of compliance for environmental or other matters are very aware of the potential criminal liability and take it very seriously. The ones who I have seen who aren't as acutely aware are smaller, faster growing companies who are used to a small business mentality. Like, for example, workers' comp doesn't kick in until you have 4 employees. So they have, in the Warren Act, when you lay off a bunch of people and you have to give them severance, doesn't kick in until you have so many employees. And so a lot of people think, oh, that doesn't apply to me yet. That doesn't apply to me yet. And so what I have seen work really well in educating companies and the individuals, particularly smaller, is some of the compliance programs that DEP and OSHA have, where you can call and ask for help. You know, we have a new business, we're not sure what we're supposed to do here. And having those programs available is really so helpful, because people are terrified to call the regulators and ask questions. And that's where lawyers can come in handy, because, you know, we can help them get through that process, but not everybody has the resources to hire counsel.
And I have a much narrower, real quick response on the corporation as a person. It was a good idea. We have now, it has slid to unintended consequences, in my view. The corporation as a person had to be established for the entity to be able to do certain things. That was the necessity of a corporate entity operation. Now what we have done is we have extended that to say, if the corporation is a person, well, then it's entitled to all the rights of a person. Now, I don't think that was ever intended, and it really is an overreach, and is unfortunately having, in a series of constitutional ways, thanks to the current Supreme Court, a much broader impact than we would have thought of 20 years ago. We understood what it meant then. Now, frankly, in y'all's generation, I don't know what it means. It could mean wide open. But again, it was not intended that corporations take on the full rights of people. I don't think.
We have time for one last question while they're setting up the final lunch preparation. So just one last question.
So I'm trying not to keep you for lunch, but I'm Sarah Gonzalez-Rocky from the National Wildlife Federation, and I really appreciate the presentation. There was a recent study about EP's efforts in the Gulf of Mexico prior to Deepwater Horizon, and their ability to be a good environmental actor and be the place where people pulled up their Prius, and this sort of greenwashing proactively in cases where they did it actually shortened the period of shame to rebound post Deepwater Horizon. So I'm wondering to what extent that will help in counseling the clients as to why being a good environmental actor on the front end will be good business for them in the long run.
Yeah, I mean, I think this is part of the increasing the benefits, which is the flip side of the shaming. There's a lot of business and goodwill in the consumer-oriented industries to being a good corporate citizen, and BP would be one example. Unfortunately, because it's such an attractive proposition, that leads to companies greenwashing, where they kind of put themselves out there, but in fact don't truly believe it or do it. And so BP conceivably, well, arguably, is one of those companies that even when it was doing all of the green sort of marketing campaigns was having problems before the Gulf, I think in Texas. Chevron is another example where now they're portraying themselves as having, we agree with all of the environmental groups, we agree with all of the things, but that people are concerned about with oil, but at the same time they're having a problem with the Ecuadorian rainforest and fighting that tooth and nail at every step. So it leads to greenwashing, but there is a genuine plus side for companies who genuinely do it. Unfortunately, there's a plus side for companies that disingenuously do it too.
Well, I think it's a credibility issue. Like I said earlier, regulators and customers are very smart, and they'll figure out for themselves what is true and what isn't. And there are going to be bad actors, and sometimes the whole company is responsible because it's a culture. Either management has funded this or not funded that, and so it really is a corporate culture issue. Sometimes it's just a few bad actors who kind of spoil it for the rest of us. But I think credibility is really important, and customers and regulators are pretty smart at figuring that out.
And my view is that in order to properly shame, you need a public entity to do it. And so you have to have strong public organizations that have credibility, that when they say Corporation X has caused X million dollars worth of damage, has done X, Y, or Z, that is the vehicle that the public will listen to. Yes, there's always going to be corporate PR and putting the best spin on things, but the hard part for the environment, for the public interest is then who is going to be able to step up and do the shaming, do the calling out. It can't be the regulator. They can't say anything other than perform their function. Competitors, individuals don't have the sort of throw weight, the credibility with the public. And so I would say yes, it's important to keep the public engaged, and when a corporate entity does something really wrong, they need to help step up and get the word out. And it's not easy, it's not cheap, but it needs to happen.
Okay, well, thank you very much. Wonderful panel.